Welcome to the Supreme Court of the United Kingdom. This is the oral summary of the Supreme Court judgment in the case of Okpabi and others, and Royal Dutch Shell Plc and another. This appeal concerns the jurisdiction of the court over claims in tort involving a defendant foreign company, where jurisdiction is sought to be founded on an alleged common law duty of care owed by a UK domiciled parent company. The parent company is Royal Dutch Shell Plc, RDS, a UK domicile company, and the parent company of the multinational Shell Group. The subsidiary company is the Shell Petroleum Development Company of Nigeria, SPDC, a Nigerian registered company which operates oil pipelines and associated infrastructure under a joint venture in Nigeria. The appellants allege that numerous oil spills have occurred from oil pipelines operated in the vicinity of their communities in Nigeria, causing widespread environmental damage, including serious water and ground contamination, as a result of negligent operation, prevention, and remediation. The appellants contend that RDS owed them a common law duty of care because it exercised significant control over material aspects of SPDC's operations and/or assumed responsibility for those operations, which allegedly failed to protect the appellants against the risk of foreseeable harm arising from those operations. In order to found jurisdiction against SPDC, the appellants need to show that their claims against RDS have a real prospect of success, and thereby a real issue to be tried, so as to meet the jurisdictional gateway under paragraph 3.13 of Practice Direction 6B for granting permission to serve the claim on SPDC as a necessary or proper party to the claims against RDS. The courts below held that they were unable to do so. The appellant's appeal to the Supreme Court raises two principal issues. One, whether the Court of Appeal materially erred in law, and two, if so, whether the majority was wrong to decide that there was no real issue to be tried. In its judgment, the Supreme Court allows the appeal. Lord Hampden gives the lead judgment, with which Lord Hodge, Lady Black, and Lord Briggs agree. Proportionality. The Court reiterates the importance of proportionality in relation to the determination of jurisdiction issues, as emphasised in the recent Supreme Court decision of Lungowe and Vedanta Resources. The analytical focus should be on the particulars of claim or witness statement setting out the details of the claim, and whether on the basis that the facts there alleged are true, the cause of action asserted has a real prospect of success. The filing of large quantities of evidential material is inappropriate. In the present case, there were numerous witness statements and files of exhibits running to over 2,000 pages of evidential material. The first issue, material error of law. The court holds that the Court of Appeal materially erred in law in that it was drawn into conducting a mini-trial, which led it to adopt an inappropriate approach to the contested factual issues and to the documentary evidence, contrary to the guidance provided by the House of Lords in Three Rivers District Council and Governor and Company of the Bank of England, and the Supreme Court in the Vedanta case. In relation to the contested factual issues, the majority of the Court of Appeal preferred and accepted the evidence of various RDS witnesses, notwithstanding the fact that there had been no opportunity for cross-examination and minimal disclosure from RDS. In relation to the documentary evidence, the Court of Appeal erred in its approach to the prospect of the disclosure of internal corporate documents material to the claims made, and the appellants were able to identify specific internal documentation not yet disclosed, which is likely to be material. The appellants therefore established a material error of law in the approach of the Court of Appeal to the determination of the arguability of the claim at an interlocutory stage. Other errors of law by the Court of Appeal were also made out. First, there is no general or limiting principle that a parent company can never incur a duty of care in respect to the activities of a subsidiary by maintaining group-wide policies and guidelines. Secondly, In relation to control, the relevant issue is the extent to which the parent did take over or share with the subsidiary the management of the relevant activity, which may or may not be demonstrated by the parent controlling the subsidiary. Finally, the Court of Appeal erred in its approach to whether a duty of care exists in this type of case, as a liability of a parent company in relation to the activities of its subsidiaries is not a distinct category of common law negligence, as made clear in Vedanta. It is not, however, necessary to determine the disputed question of whether such errors were material to the decision reached. The second issue, real issue to be tried. Having full regard to the parties' submissions and evidence, it has not been shown that the asserted facts in the particulars of claim should be rejected as being demonstrably untrue or unsupportable. On that basis, the appellant's pleaded case, fortified by the points made in reliance on the two RDS internal documents so far disclosed, establishes that there are real issues to be tried in light of the guidance in Vedanta. That conclusion is further supported by the evidence of the appellant's witnesses and the very real prospect of further relevant disclosure being provided. In particular, the Shell Group's vertical corporate structure, with organisational approval generally preceding corporate approval, allowed for delegation of authority, including in relation to operational safety and environmental responsibility. How this organisational structure worked in practice and the extent to which authority was delegated clearly raises tribal issues. The majority of the Court of Appeal was therefore wrong to decide that there was no real issue to be tried. In conclusion, the appeal is allowed. If the respondents intend to pursue the other challenges to jurisdiction which were not resolved by the High Court judge, the matter will have to be remitted to the High Court.